we're going to be hearing from a panel of three wonderful policy experts who are going to be able to provide us a little bit of a deeper context for some of the policy options that we've already started to wrestle with, to help us understand how to use some of these tools in our toolbox, if you will. So I'm going to introduce all three in just a moment. We're going to hear from each of them in succession for about 13 to 15 minutes, and then we'll have time for a 10-minute Q&A following each presentation. And of course, our presenters are welcome to yield time from their presentation if they want a bit more Q&A. At the end of the presentations and the Q&A, we're going to break out once more into small groups again, with each group focusing on a particular policy option from the three presentations, and we'll come back afterwards and go off to lunch after a quick recap. So without further ado, let me introduce our three speakers. First, we're going to hear from Sarah Slinn, Associate Professor of Labor and Employment Law at Osgoode Hall Law School, who will speak to us about broader-based bargaining, which was option 6 on that starting list of 15 you saw this morning. Next, we'll hear from David Dorey, Associate Professor of Work Law at York University and Director of Osgoode Hall's School of Labor and Employment Law program, who will talk to us about minority unionism, which was option 5 on your policy list. And thirdly, we'll hear from Roy Adams, Professor Emeritus of Industrial Relations and International Labor Law at the DeGroote School of Business at McMaster University, who will present about the concept of work councils, which I know was interesting to many of you, policy option number 9 on that starting list. So without further ado, let me hand things over to you, Sarah, to get us started. Welcome and thank you so much for joining us today.
Thanks very much, and good morning, everyone. I really appreciate the time and careful thought you're all dedicating to these really important questions of workplace reform. So I've been asked to talk about broader-based and sectoral bargaining today. It's a complex area. There are many possible models here. So in the brief time that we have here, I'd like to do two things. First of all, introduce this concept and offer a bit of a conceptual mapping of it. And secondly, discuss the examples that you've been introduced to so far in this program, and then locate these on this map. The idea here is to help you to be able to understand and assess broader-based and sectoral bargaining options. So as you've been discussing, the Wagner model characterizes general collective bargaining statutes in North America. And one pillar of the Wagner model is exclusive representation. So a single bargaining agent, and it's oriented towards what's called enterprise bargaining, where there's a single workplace, a single employer, and typically a single union. Now that said, statutory and informal broader-based and sectoral bargaining has long existed in Canada, both inside and outside of and as part of the Wagner model. But enterprise bargaining with a single union does characterize this system. And it comes with some limitations. It makes organizing of workers difficult. It's costly to unions and employers to negotiate and administer on an enterprise, a collective agreement on an enterprise basis. It encourages competition among organizations based on labor cost rather than productivity cost. And overall, it's a poor match to the current fissured organization of business and work. So if we, as a counterpoint to enterprise bargaining, if we talk about broader-based and sectoral bargaining, what are we talking about? Fundamentally, we're talking about bargaining and representation that is broader than enterprise-based representation and bargaining on the dimensions of how many employers are involved, how many workplaces are involved, how many groups of workers are involved, and how many unions are involved. And the far end, the broadest form of broader-based bargaining is sectoral bargaining, where you have an entire occupation or an entire industry in a particular region, such as a sub-provincial region, a province, or a nation. Bargaining occurs on that sectoral level. In other words, it encompasses a whole sector, the idea being that it captures the entirety of the labor or product market. And so what are the benefits of broader-based and sectoral bargaining? Well, first of all, if you capture a significant proportion, or ideally all, as in the case of sectoral bargaining, of the labor or product market, you can convert labor cost competition to productivity competition, and thereby hopefully improve the productivity of enterprises. There's also evidence that where sectoral bargaining is used, you see greater equality, so reduced inequality among workers, and greater coverage, greater worker representation. So if we can turn to the next slide. Thanks. So here I've provided a map as a way to try and understand and compare different broader-based and sectoral bargaining options. And the way this map is organized is it has two key axes. So two key dimensions or variables along which to understand and locate different options. And the first is the horizontal axis. So you'll see in blue that this runs from, on the left-hand side, enterprise level negotiation, so the typical Wagner-based negotiation, to, on the far right side, sector level negotiation. And within the span of that axis, we see from left to right, increasingly broad bargaining. So running from multi-workplace, but still single employer and single union, to multi-employer, potentially multi-union and multi-workplace, eventually on the right-hand side, arriving at sector level negotiation, where it's multiple employers, multiple worker representatives, and all of the workplaces and enterprises in the sector. The second axis is the vertical one, again in blue also. And at the top of the axis, we see this axis deals with the nature of the bargain, the nature of the bargaining that occurs, and the nature of the bargain that's arrived at. So at the top of this axis, we have bargaining. And this is the traditional bargaining that you're familiar with, where the relevant parties negotiate and reach an agreement. And that negotiated agreement is what becomes enforceable. At the bottom of this particular axis, we have a different form of bargaining. It can be called, and in some contexts is called, public bargaining. And this is where the negotiation occurs between not only worker representatives and employer representatives, but also government representatives and possibly representatives of the public. The other key distinction between public bargaining and bargaining on the other end of this axis is that the agreement that results is a recommendation that is then given to government, and government can unilaterally accept, reject, or modify that. So therefore, government, rather than the parties themselves, decides what will be the enforceable output of that negotiations. So we will, this mapping, this axis, then creates four rough quadrants. In the upper left quadrant, we have broader based bargaining. So it involves multi-workplaces, possibly multi-employers, possibly multi-unions. And traditional bargaining, producing a traditional collective agreement where the parties agree and determine what the enforceable output will be. The upper right, or I'll move to the lower right quadrant, is where you have very, very broad-based bargaining, indeed possibly sectoral negotiation, so that representation and bargaining occurs, for example, on the basis of all fast food outlets in British Columbia, or all fast food outlets in California. The bargaining, however, is this public bargaining model, where the negotiations produce recommendations that are accepted or amended or rejected by government. The upper right quadrant is similar in the sense that it also involves sector level negotiation, so very, very broad negotiations, but the output is a collective agreement. So the parties themselves negotiate and produce the output that will be enforceable. So we'll return to this to map some of the particular examples that you've been introduced to in this program. So if we can move to the next slide. So my understanding is that you've been prompted to look in particular at fast food industry and sectoral and collective and broader-based bargaining in this industry. So there are two examples of broader-based bargaining models that have been tailored, created for the purposes of application to the fast food industry. The first is the Changing Workplaces Review, Recommendation 157, and the second is the California Fast Recovery Act that was introduced to you in the policy debate the other week. So I'll introduce these two briefly. I understand that you are to some degree familiar with them already, and then we'll take a look back to the map and locate them in comparison with some other options and some other examples. So Recommendation 157 is really based on the Wagner model in the sense that the franchisees, it applies to franchisees of the same franchisor, which have already been certified under the Ontario Labour Relations Act, for example, by the same union, not by different unions. So negotiations would then occur between a council of employers, franchisees, owners. This would produce a collective agreement that would bind all of the franchisees that are involved in this and the union. And ratification of this collective agreement and any industrial disputes arising from it would involve everyone, all of the workers and all of the franchisee workers that are involved. So it is certainly broader based than the typical enterprise approach. In contrast, the California Fast Recovery Act does not require recognition. It doesn't require certification as a precondition for the model to apply. It simply, should this be passed, simply will apply to any chain where there are 100 and more stores nationwide that have a common brand. The negotiation will occur between a council, a multi-member council with worker, employer, and government representatives. So in the sense, it's the public bargaining we were talking about, the vertical axis. And the outcome of these negotiations is a recommendation to government about certain minimum wages and working conditions. What this would produce is, if then accepted by the legislature, it would produce minimum standards applying to all the workplaces in that statewide sector. So there are similarities, but there are also differences between these two approaches, both of which have been tailored to the fast food sector, which is characterized by a lot of franchisees and a lot of small, very small enterprises that have been historically very difficult to organize. Can we move back to the second slide? So moving back to the second slide, we can locate these on our mapping here. So the Recommendation 157, we see this located up in the left quadrant, right? It is traditional bargaining between parties. It is multi-employer and multi-location. It is, however, one union, and it produces a typical, a traditional collective agreement. If we look at the California Fast Recovery Act, that is located in the bottom right quadrant. Why? It is truly sectoral negotiation. It is all locations of a certain size in the entire state. So very much broader than the Recommendation 157. However, the nature of the bargaining is different. It is public bargaining. right? It's this council, a tripartite council, including government representatives, that produce a recommendation about minimum standards. Now, so we have two very different, in some ways, although similar in other ways, proposals that deal specifically with fast food. If we look at a third example, the New Zealand Fair Pay Act, which I understand you've also been introduced to, that would be located up in the upper right quadrant. This would be true sectoral bargaining in two senses. First of all, it is an entire nationwide bargaining for a particular occupation or particular industry. All employers and all workers nationwide are involved. It does not require the traditional recognition or certification requirements of the Wagner Act. The bargaining is the traditional type of full bargaining between the employer representatives and the worker representatives, producing an agreement that is binding. The agreement is for minimum standards that apply across the sector, so nationwide across the industry or occupation, but doesn't require government approval and isn't subject to government, a modification unilaterally that public bargaining will be. So hopefully this mapping, conceptual mapping, will help you sort of locate and understand and be able to compare the different kinds of options that you're talking about. Again, the key is the horizontal axis. What level is the bargaining occurring at, from enterprise to full sector, nationwide or province-wide, and the vertical axis of what's the nature of the bargaining and the outcome of the bargaining. Is it like a collective agreement where the parties themselves determine what the binding terms will be? Or is it public bargaining, where government and or public representatives are involved in the negotiations, and the negotiations produce a recommendation that government then implements or modifies? Thank you. I think I'm at time, Richard.
Perfect. Thank you very much, Professor Slinn. You are indeed at time. Thank you so much for that introduction to some of the finer points of broader-based bargaining. I think some of our members have had a little experience with this in the industries you mentioned. Others may have not. So it'll be interesting to see. But let me hand it right over to our members. If anyone has a question you'd like to pose to Professor Slinn about her presentation or about how we might think about some of the trade-offs that she put to you with these different types of things, please feel free to raise your Zoom hand or put a question into the chat. Let me just emphasize, if you have more of a comment, we'd prefer if you put that into the chat. We'll make sure it gets to the attention and we'll focus on questions. Jillian, I see your hand is raised first. Please go ahead.
Yeah, so in terms of public bargaining, what is the you say you have here in brackets like the government enacts this. Is the recommendation something that the government will enact, or is it simply a recommendation that they might enact?
That can be crafted in a number of different ways. Typically, it is it's subject to the approval of whatever government body it goes to. That may be the Minister of Labor, it may be the legislature itself. The California FAST Act has put in not a presumption, but it's strongly weighted towards acceptance of the recommendation. There are numerous other models that in existence which also use public bargaining, particularly in the United States, various wage boards models. And there, it really is up to whichever government body or entity receives the recommendations. Again, they can modify it if they find it appropriate, or reject it. They could send it back to the negotiating group to revisit. So that can be dealt with in a variety of different ways, and the legislation sort of sets out how that will be approached and the degree of discretion that the government body has on accepting, rejecting, or unilaterally modifying or sending back to the negotiating group these recommendations.
All right, thank you. I see Dandy has her hand up next. Dandy, please go ahead.
Yeah, I'm gonna come on video for a moment. Hi, thank you very much for the presentation. I found it very interesting. So traditionally, when I think about unions, I think about, FTE employees, right? Like they're full-time, but with the sectoral bargaining, does this include, individual, for example, contractors, right? Because technically these people also belong to an industry. I want to understand, is there a boundary there, or does the sectoral bargaining kind of step across that boundary between, like a full-time employee versus, everybody in this industry?
There are definitely examples of existing and past sectoral bargaining legislation that includes not only worker categories as defined by the definition of employee and independent contractor, but also include independent contractors. And certainly that's there are a variety of sectoral bargaining models that are contemporaneously sort of in discussion, and that's one part of the discussion. How broad is the application? Now, for sectoral bargaining, the idea is to be as comprehensive as possible, to cover the entire sector in terms of enterprises and workplaces and workers, because one of the goals is to eliminate or reduce at least labor cost competition. So if you have groups of or categories of employees, such as independent contractors, who are not covered by that, then clearly that diminishes the ability of that model to positively affect labor cost competition. So that said, it's often very controversial, and employers quite often do not want, for example, independent contractors to be covered by sectoral bargaining models for those very reasons, because some employers still want to engage in labor cost competition. So the short answer being, it depends on how you structure the sectoral bargaining model. It can absolutely be structured, and many have been structured, to include all categories of workers, including the non-standard, non-typical full-time employee, including independent contractors.
Very cool,
Right.
thank you. Yeah.
Thank you so much. I think we have time for 2 more questions. So I see that we're going to get to Fatima and then Sandra. You'll be next. So Fatima, please go ahead.
Hi, Ms. Slinn. So I recall as you mentioned in sectoral bargaining, it's kind of like more private in a way, like it's not public basically. Is that what you said?
The terminology public bargaining is chosen or used simply because that's a traditionally used term. And it arises from some early US legislation where the negotiations were between employer representatives, worker representatives, and representatives of the public, citizenry. And so it became labeled public bargaining. So, and there's public input often into the negotiations in those models, in the sense that they hold public hearings to gather information. So the counterpoint is not public versus private in the sense that you may be thinking of, if that's helpful.
Okay, and for sectoral bargaining, you said it's not necessarily subjected to any government modification and whatnot? Like they kind of create their own policies and everything?
The upper right quadrant here is sort of the true sectoral bargaining, in the sense that it's furthest to the right of the horizontal axis, being as broad as possible in terms of the number of employers, number of enterprises, groups of workers that are covered. And it's also to the top of the vertical axis, where it's real bargaining, in the sense that the representatives of those affected, the workers and the employers, are the ones who negotiate and come to an agreement, and their own agreement is what becomes binding, rather than what may be approved or modified unilaterally by government, if that helps.
All right,
Okay.
thank you so much.
Yeah,
Let-
thank you.
Let me offer Sandra our last question for Professor Slinn, and of course others, if you do have questions or comments, feel free to put it into the chat. Sandra, please go ahead.
Yeah, thanks for this presentation, Sarah. Can you elaborate a little bit on your assumption, which I am kind of seeing here, that productivity-based competition is better for workers than labor cost-based competition? And perhaps in a similar vein, is it like, why are we assuming that it's either labor cost and productivity, or, you know, wouldn't workplace conditions play into that as well? Could you just elaborate on that?
Sure. So labor cost competition tends to be, I realize we're in a moment right now where there's a tight labor market, and therefore workers have a certain amount of bargaining power in terms of getting better terms and conditions of work. That's not always the case. And labor cost competition problematically is typically where enterprises try and lower their overall costs of production by reducing input costs. So reducing the input costs of labor. So compensation, workplace conditions, reducing those costs as much as possible. So typically that would be negative for workers. Sorry, can you remind me of the second part of your question?
Yeah, so my question on that is, so if you then switch to a productivity based competition model, I mean, that could be negative for workers as well, if there's immense pressure for workers to be more productive. You know, I'm wondering how workplace environment and work conditions would factor into this as well.
Good question. And, you know, hopefully if there is a collective agreement or a sector agreement of some sort, or minimum sector standards, that could at least in part address that. At the very least, you'll have minimum standards addressing workplace conditions.
All right, thank you so much, Professor Slinn, for that, and for everyone for participating.